For centuries, copyright law was pretty straightforward. If you write it, you paint it, you compose it, you own it. Simple. But what happens when the creator isn't a person at all? We're about to dive headfirst into this massive collision between cutting-edge artificial intelligence and the very definition of creativity in the eyes of the law. Okay, take a look at this. This image is called a recent entrance to paradise, but it wasn't made by a human artist, not in the way we usually think. The person behind the AI claims this piece was generated, and I quote, autonomously by a machine. And that single claim kicked off a legal fight that went all the way up to the US Supreme Court.
And this forces our legal system to tackle a really profound question. Who or what can actually be an author? Is it the person who coded the AI? Is it the AI itself? Or could the answer be nobody? Answering that is at the heart of everything we're talking about today.
So here's how we're going to break it down. We'll start with the legal case that started it all. Then we'll unpack this thing called the human authorship rule. After that, we'll talk about AI as a tool, see what other countries are doing, and finally, take a look at what the future of copyright might hold. Let's get into it.
First up, the story that really set the stage for this entire debate. And this isn't some theoretical what-if scenario. This was a real-world legal challenge that forced the U.S. court system to draw a line in the sand. So on one side, you've got Dr. Stephen Thaler. He's an AI researcher. And on the other, you have his creation, an AI system he named Dabus, which he calls a creativity machine. Thaler specifically designed this system to generate brand new art and inventions, supposedly with no human guidance at all.
So back in 2018, Thaler tried to get a copyright for this artwork, and he listed the AI as the author. The U.S. Copyright Office said nope, so Thaler sued. But every single court, from the district court in 2023 to the Court of Appeals in 2024, sided with the Copyright Office. And to top it all off, the Supreme Court just declined to even hear the case, which basically cemented all the lower court decisions. So why was every single door slammed shut?
Well, that brings us to the fundamental legal principle that stopped Thaler's claim in its tracks. And it's a concept that's been baked into U.S. law for more than 100 years.
It's the human authorship principle. And yeah, it's pretty much exactly what it sounds like. To get a copyright in the United States, a work has to come from a human mind. The whole point of the law is to protect the fruits of intellectual labor, and that labor has always been assumed to be human.
What's really telling is just how direct the court was about this. In its 2023 ruling on Thaler's case, the judge didn't mess around. They called human authorship a bedrock requirement. That tells you this isn't just some minor detail, it is a foundational pillar of the entire copyright system.
And this idea of non-human authorship has actually been tested before. I'm sure a lot of you remember the famous monkey selfie case, right? A macaque named Naruto took its own photo. The courts decided that animals can't be authors under the Copyright Act. So the logic they applied to Thaler's AI was pretty simple. If a living, breathing animal can't be an author, there's no way an inanimate machine can be one either.
Okay, so this brings us to a really practical point for anyone who's actually using AI today. The courts have drawn a very clear line in the sand. There's a huge legal difference between an AI acting as a creator versus an AI acting as a really sophisticated tool.
So, does this mean any piece of art made with an AI is automatically just thrown into the public domain for anyone to use? Well, the answer is a definite no. The critical thing here is all about who is ultimately in creative control. This table really lays it out perfectly. If a work is generated completely by an AI on its own, like Thaler claimed his art was, then there's no copyright protection. It belongs to the public. But if a work is created by a human using AI as a tool, the same way a photographer uses a camera, then that work can absolutely be protected.
So the next logical question is, what counts as enough human input? Well, the U.S. Copyright Office has actually given us some guidance. They're looking for real, creative contributions from a person. This could mean things like how you select and arrange the AI-generated images, any creative edits or changes you make, or even the written prompts you use, especially if they have specific, creative instructions. A perfect real-world example of this is the graphic novel Zarya of the Dawn. The creator used AI to make the images. Now, the Copyright Office said, yes, we will give you a copyright for the parts you created, the text, the story, how you arranged everything, but, and this is a big but, they specifically denied copyright for the individual raw AI-generated images inside the book. So you can see this path for a kind of partial hybrid copyright.
Okay, so while the US has drawn a pretty clear line for now, this whole thing is a global issue.
So let's zoom out a bit and see how other countries are trying to solve this exact same puzzle.
This slide gives us a great snapshot. You can see the US and the EU are pretty much on the same page. No AI authors. The EU has the standard that a work has to be the author's own intellectual creation, which, implies a human. China is a little more flexible. But the really interesting one here is the United Kingdom. They have this unique law for computer-generated works that gives the copyright to the person who made the necessary arrangements for the work to be created. It's a totally different way of looking at it.
And that brings us to our final section. Look, the question of whether an AI can be an author seems settled for now, at least in the US. But that was just the opening act. The truly massive legal battles are still on the horizon.
These are the billion-dollar questions that courts are going to be wrestling with next. Is it even legal to train AI on huge libraries of copyrighted material? That's what huge lawsuits like the New York Times versus OpenAI are all about. If an AI creates something that infringes on someone else's copyright, who gets sued? Can a really complex, beautifully written prompt be copyrighted all on its own? And as AI gets more and more autonomous, who's legally on the hook for what it does?
The way things are now, with this human authorship rule, we're seeing a tsunami of AI-generated content flooding into the public domain, totally free for anyone to use. And that reality is forcing people to ask, is our current system, which was designed for human creativity, really built for the age of AI? Or do we need something brand new?
One of the most fascinating ideas being talked about is something called synthetic copyright. Now, this wouldn't be like a normal copyright. It would be a new kind of intellectual property right built just for AI. It wouldn't call the AI an author, but it would give a limited term protection, maybe 5 to 15 years, to the person or company that's running the AI. The goal is to encourage people to invest in AI without locking up our culture for nearly a century.
And it's so important to remember that copyright law has never been static. I mean, when photography came along in the 1800s, people in courts had to debate whether a machine capturing reality could even be considered art. Eventually, they decided it could. The laws always had to stretch and adapt to new technology. AI is just the latest and maybe the biggest test of that flexibility.
So if you take away one thing from all of this, let it be this. As of right now, the law sees AI as an incredibly powerful tool, not as an author. If you're a creator using these systems, the path to owning your work is clear. Your own human creative spark isn't just important, it is absolutely essential.
And that leaves us with one final thought to chew on. We've established that for now, AI is a tool. But as these systems get more and more sophisticated and start to evolve from a simple instrument into something that feels more like a creative partner, how will our laws have to change? And what will our definition of an author even look like 10 years from now?